You've been covering this for a while now for Forbes, and in a recent piece, you said that the HEROES Act is really going to come into play here. Can you elaborate on that?
So the HEROES Act is a statute that was passed in 2003 that grants fairly broad authority to the Secretary of Education to waive or modify any federal student loan programs and provisions associated with those programs in response to a national emergency. And the Biden administration used that statute as the basis for providing this relief, saying that the national and widespread economic impact of the pandemic resulted in widespread harm, and this is designed to remedy those harms, or at least put borrowers in a place where they would be no worse off than they were before the pandemic began. The HEROES Act is central to this. A large portion of the hearing yesterday was devoted to parsing the meaning of the words modify and waive. There were a couple of judges that seemed to suggest that because Congress did not use the words cancellation or forgiveness or discharge in the actual statute, that could be a problem. But the counter argument, the Solicitor General said during the hearing, was that, look, Congress knew what they were doing, and they wrote this in a very broad way. They said waive or modify any programs associated with federal student loans, and that would include, provisions related to loan repayment and loan forgiveness as well.
Both the Biden and Trump administrations pointed to the HEROES Act both to enact and continue student loan payment pauses. Why is it that Biden's use of the HEROES Act is being scrutinized here?
Well, there seemed to be general agreement, even with the more conservative justices on the court, that it was okay for both President Trump and President Biden to rely on the HEROES Act to initiate and then extend the pause because forbearance was a program that could be modified. The argument that the challengers are presenting, at least in the GOP state case, was that this wasn't a modification of an existing program. It was essentially the Biden administration creating a new program, which is not allowed by the HEROES Act. And so they tried to distinguish what they argue is the legality of the payment pause extensions with what they're arguing is an entirely new program.
Let's talk about some hypotheticals here. Let's say the Supreme Court strikes down Biden's plan. Is there a backup plan?
The administration has publicly stated through various officials that there is no backup plan. That being said, a lot of consumer advocates have suggested that the Biden administration could, if needed, reissue the plan under a different statute called the Higher Education Act, which does have a provision as well that grants broad authority to the Secretary of Education to waive or even cancel or discharge federal student loan debt in certain circumstances. That would probably be a more difficult process. It would be longer to create a new program because they would have to go through the normal regulatory process as opposed to relying on emergency regulations. But this issue actually came up in the hearing, and there was some discussion on both sides that the Higher Education Act could provide an alternative basis for the program.
So let's talk about final thoughts from yesterday's hearing. Are you feeling optimistic for borrowers, pessimistic for borrowers, somewhere in between?
I would say I'm somewhere in between. I do think that from the borrower's perspective, from the government's perspective, the hearing probably went a little bit better than maybe people were expecting. That being said, it's still a tough hurdle here. There's a 6-3 conservative majority. The court has already struck down a number of Biden administration emergency initiatives, and those cases were discussed during the hearing as well. I think that ultimately, while a majority of the court did express deep skepticism about the legality of the program, I think that the case is probably going to turn on the issue of standing, whether the parties who brought the challenge can demonstrate an injury sufficiently connected to the program itself. And I do think that it's an open question as to how the court will rule on that issue. It's possible that if they uphold the program on the basis that these challengers don't have standing, the court doesn't even need to address the underlying merits. And that could be a way that the program ultimately survives, but we'll have to see.
Have the challengers been doing a good job so far of addressing standing?
An excellent question. I would argue that I think the government did a better job of addressing standing before the justices during the hearing yesterday. Both challengers were grilled by many of the justices about whether the challengers could actually prove that they could withstand a challenge on standing. We'll have to see what happens.
And borrowers have really been in limbo since March of 2020, when the student loan payment pause first went into effect. Now, what can they expect next?
So the payment pause it continues to go until June 30th, or 60 days after June 30th, or whenever the Supreme Court rules on this case. It's unclear at this point if that's the final extension or if it could be extended further. There were some hints during the hearing yesterday that the administration could potentially extend again. I think that will also turn on how the Supreme Court rules on the student loan forgiveness case.
Adam, you've been regarded as the national authority on student loans. So in the meantime, between now and when the borrowing does end, or the payment pause does end, or there's a decision on this case, what should borrowers do?
Well, borrowers should make sure that their contact information is up to date with all their loan servicers. They should be exploring their repayment plan options and anticipating a return to repayment by the summer. They should also evaluate their eligibility for some separate initiatives that are not being challenged right now, such as the IDR account adjustment, some new upcoming changes to public service loan forgiveness, borrower defense to repayment. There's a whole bunch of other initiatives that could be helpful to folks separate from the one-time cancellation, and it would be worth it for borrowers to look into those options.
Adam Minsky, thank you for the update.